Broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to the Micklin Law Group's monthly webinar series. We will be starting in just a minute. I hope that you can hear everything that I'm presenting. This is obviously a one-way recording. So I'm going to give a second to see if anybody is going to sign on, and then we'll start right into it. All right, so my name is Brad Micklin. I'm the attorney and managing member of the Micklin Law Group. We are a law firm concentrated in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. There is a QR code on the screen that would enable you to book an appointment on my calendar if you're a client or a potential consultation. Keep in mind, if you're a consultation, you'll get an email that you do need to call for an intake to confirm that meeting, but I do try to make it as convenient as possible to get in to see us. So I have also served as a national legal media consultant. I've made numerous appearances. I've been on Fox News, Inside Edition, Larry King when he was with us, I-24 International News, and many others. I say this not to impress anybody, but to impress upon you the experience and breadth of my knowledge and background, with the hopes that you can trust and find confidence in the advice and recommendations I'm going to make to you both today and in my other webinars. I also have been honored to receive several awards and accolades, both from client reviews and peer surveys. Again, this is just to explain the background that I bring to this, hopefully a unique, pragmatic approach that seems to have served a lot of people well in the past. So let's jump into it. Today's webinar is Maximizing Your Parental Rights, a guide for fathers seeking custody. Fathers seeking custody face unique challenges. With the right knowledge and strategies, it's possible to maximize parenting rights and build strong family relationships. Again, we at the Micklin Law Group do concentrate on men and fathers' rights, and this is going to be a brief webinar on how to prepare both before and during some litigation. You'll also note, or I'd like you to also note, that I have a numerous amount of videos and webinars on my YouTube page, Brad Micklin. I think it's Brad Michael Micklin, like this webinar slide is showing. And also at themicklinlawgroup.com. Both are very robust in the information that we provide for you. All right, so let's jump into first, understanding custody laws, legal knowledge, rights and obligations, and seeking legal counsel, the topics I'm going to briefly discuss. First, legal knowledge. Understanding the intricacies of custody laws is vital. It involves learning about legal terminology, court procedures, and the factors that the courts consider when determining custody. And that last part is probably the most important for you. There are at least 14 separate criteria that judges are required to review and critique when determining any custody application or change in custody application. I did not put a site. I'm not going to give you a site. You can just go to any web browser, put New Jersey custody factors. You're likely to get returned to the proper site. In addition, you want to know the types of custody. And again, I'm not going to go into everyone in depth because it's a little too broad for this, but I do have additional webinars on my YouTube page and my website, which you will hear me say countless times throughout this presentation, just so that you remember to check those sites. But basically speaking, there's parent of primary residence and alternate residence. There's sole and legal custody, and then there's joint and shared physical custody. All of these are important. They are often overlapping. So it is important to get a basic understanding of them. I do always counsel people not to use specific terms when discussing custody unless you really fully understand and appreciate the differences, because you may ask for the wrong thing or suggest the wrong intention because you're using the wrong term. Just indicate what you're looking for. Speak in terms of time sharing, speak in terms of decisions, speak in terms of overnights, and your information will be clear to whomever is deciding these factors, whether it be in a courtroom or in a settlement conference. Rights and obligations. Fathers need to know their legal obligations and rights. This includes understanding visitation rights, or what we now call parenting rights, child support, and the impact of any criminal history or substance abuse issues that may be underlying. Again, this does parlay back to the 14 different factors that I referenced a moment ago. This is highlighting some of them. Obviously, criminal history, substance abuse are going to be seriously impactful into custody determinations. But the broader issues also, as we discussed briefly, you want to understand, visitation versus parenting rights. It's a terminology that's very significant because you are not a visiting parent when you have your child, but you are parenting, which means you make the decisions. You are responsible for what happens during your time. There's parenting time and child support rights and obligations. They are in New Jersey separate and apart, meaning you can have an order that requires you to pay child support, and that doesn't mean that you're going to get an order that entitles you to parenting time or custody. They do need to be separately sought and ordered. And lastly, there are college obligations, rights, and responsibilities that are separate and apart from the child support laws and the child support obligations. It can be, in some cases, in addition to or as a substitute for, but it is something that you want to get some understanding if you have children around those ages or you expect them to be there soon. And I say that because, most children you might consider to be there soon, even if they're infants. But the laws may change so drastically in a time period that unless they're several years away, I wouldn't really dive into college issues just yet. And lastly, on this slide, seeking legal counsel. Consider consulting with a family law attorney who specializes in child custody cases. They can provide personalized advice tailored to your specific situation. And I don't say this because I am an attorney. I say this because even I hire attorneys when I need help with a matter that's beyond my experience. If I was buying a house, for instance, I'd have an attorney. If I was writing a will, I would have an attorney. If I was fighting for custody of my child, I would have an attorney. I got divorced. I had an attorney. I think you get the point. Now let's turn to the courtroom drama. Building a strong case, evidence collection, parenting plans, and emotional support. All three separate and important issues. Evidence collection. Gather evidence that proves involvement in your child's life. This could include school records, medical records, and witness statements. Now, this is going to be important because you do want to get these documents. You want to get them in writing. If you have witnesses, you want them to put down in writing what they intend to say. If you have report cards, extracurricular activities, doctor reports, you want these in writing. But you also want to talk to these individuals to make sure that they understand and confirm the information that you have, that they're going to be willing to testify, because the statements that you get, that I'm telling you to get in advance, which are helpful, are not going to necessarily be admissible in court, a topic we'll talk about separately, and I've covered in many other webinars. But it's a starting point so that you know what's going to be said. And then once you have the statements and you have the documents, if you're going to be representing yourself, you want to learn some of the basic evidentiary rules about admissibility of documents, how to get statements in, how to get records in, what are the exceptions that courts will look to if these aren't readily admissible, and how to get around that. And I do, again, have webinars on my YouTube and my website that will cover these topics in greater depth. Parenting plan. Create a comprehensive plan that demonstrates the willingness to provide a stable, nurturing environment for your child. And you need to consider a lot of things. First, globally speaking, you want to think about how your schedule may need to change in the future. If your child is 3, think about what's going to happen when that child goes to school or changes school, or when somebody moves or gets married or divorced. But then also more specifically, when you're considering a parenting plan that you're going to be either offering to the court or trying to resolve with the other parent, you want to consider your birthday, the child's birthday, Father's Day, what holidays you celebrate, time in the summer, the school vacations. And surprisingly, you want to consider what the other party or parent will want. It's always helpful to keep in mind, be generous with your parenting time, because the plan that you're going to create is sort of your basement level rights, meaning that's the minimal that you're entitled to. You hope always to have more. Well, the way to get more is to have cooperation and a good relationship with the other parent. That parent may too also need changes and accommodations, so you give and you get. So when you're considering your parenting plan, think about where the conflicts with the other parent may be, what that person may be looking for, and see if you can accommodate that plan without compromising your own. And if there's long distance between the two parties, I mean like travel distance, like airplane distance, you want to think about how you can maximize your time. If you're the one that's further apart, you want to consider traveling costs, which is significant depending on who was the one who actually created the distance, which may or may not impact who pays the cost of traveling. And lastly, emotional support. Seek counseling or therapy to illustrate efforts to address emotional well-being and parenting skills. And this is actually good, not just for you to have somebody to help you through this, but you may also need somebody to come and testify, and that probably needs to be somebody separate, not like a therapist. Normally they can't testify on a client's behalf. But you want to have your own emotional support, and you may want to consider somebody that can testify to your mental health, the child's need to have your involvement, as well as the plan that you may be proposing. Now let's talk about some strategies to accomplish this. Co-parenting strategies. 1, effective communication. 2, consistency and flexibility. And 3, always and paramount, the child's best interest. Effective communication. Developing a co-parenting relationship based on open, respectful communication is key to successful custody arrangements. Now, to many, that may seem far-fetched or even impossible, depending on the nature of your relationship and what brought you to this. But we hope that you do develop a good, open, respectful relationship. Even if that other parent is not, you want to do your best to try to foster that. First, it's always better for your child or children, and it will help you in court when the judge sees the greater effort you're making for effective communication. If the relationship is problematic, I always recommend keeping records of the conversation. If you are in New Jersey, and by the way, this is a New Jersey webinar, and it's under New Jersey law, and it's, by the way, in February of 2024, in case the law has changed, and if you're watching this later. In New Jersey, you can tape and record another person in New Jersey without that person's knowledge. If it's a problematic relationship, I usually recommend that you do so, with a caveat that in some cases, judges don't look favorably on that because many reasons, but essentially they know you're on your best behavior when you're recording somebody who may be at their worst behavior. But nonetheless, I still think it's better to have a recording and have the court frown upon it than to not have it and have to be proving yourself. Emails and text communications, you want to keep them. I did a 2-part webinar series, I think in 2020. And I say that only because it was right around the beginning of the COVID-19 quarantine. And how to use emails tactically to save and document communications, but also to be able to retrieve them for litigation purposes. So I'd suggest that you watch that, can be very helpful. And there's many apps out there, or the most popular with the New Jersey Family Court is Our Family Wizard, which will help you utilize and document communication with each other so that you can reproduce them in court. I hope that I'm still recording, because I stopped the recording and then I started again. I'm not even sure how that works. Consistency and flexibility. Working with the other parent to establish consistent rules and routines while also being flexible to accommodate each other's schedule. Sorry if there's any hiatus in the recording. I had to pause and start again. So getting back, consistency and flexibility. Working with the other parent to establish consistent rules and routines while also being flexible to accommodate each other's schedule. Sort of goes to what I was saying a little earlier about open communication, but this is more about accommodation in your relationships. And like I said, you give and you get. When one party needs an accommodation, certainly I recommend you try to accommodate, and then in the future remind them so that you can get an accommodation. You may want to do it at the exact same moment, depending on the nature of your relationship with that individual. If they're asking for an accommodation, say, great, more than happy to accommodate you. But in return, I would specifically like this accommodation. So you don't have to hope in the future to get the accommodation if there's a chance that it would be rejected. And if you find that you often don't get accommodations or respectful communications, then don't give the accommodations that are sought. I find myself saying this to a lot of people because a lot of people operate under a feeling of reciprocity, meaning they believe if they give and are generous to somebody and accommodating, that person will be generous and accommodating in return. And human nature dictates that many, if not most, people are that way. However, there are that unique few who are not that way, that are unreasonable and unbending. And when you accommodate that kind of person, you reinforce the bad behavior, meaning if they refuse an accommodation, so you change your needs, they will do that in the future because it was an effective strategy. So you need to balance accommodations with rigidity when you have a less than accommodating other parent. And lastly, child's best interest. Always prioritize child's well-being and best interest in co-parenting decisions and interactions. This is the overall theme, both in our legal jurisprudence, in our philosophy, and in most people's approach to children. And the thing to remember is it's the child's best interest. So there's two parts. First of all, it's the child, meaning not the parent. So for instance, a lot of people will say, I want to move and change custody because I'm getting another job. Well, that's in the parent's best interest. That doesn't necessarily benefit the child. Now, arguably, more income, maybe more autonomy, blah, 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 whatever it might be, could be, in fact, inure to the child's interest, but it's not necessarily for the child's best interest. So you would need to indicate why that is so. And the second part that gets overlooked is its best interest, not good or better. Again, a lot of people say, I need to relocate because I have family support in another state. Well, that's good, and that might even be better than what that parent has here. But that doesn't necessarily mean it's best and it's best for the child. So when you're arguing child's best interest, which you will need to because that's the overall philosophy of everything, you need to keep those distinctions in mind and always argue with the distinctions of this is best and it's best for the child. Now, talk a little bit more about documenting your involvement, as I mentioned a little bit earlier when it came to emails. Quality of time, child development, and engagement with school, to name a few. Quality time. Document valuable time spent with the child through photographs, videos, and journaling daily activities. I also often recommend a Google Calendar because it allows you to add notes and upload documents, and you can easily access it on countless devices. The courts may even have the ability to access with the new rise in virtual appearances and implementation of technologies in the court. Going back also, as I mentioned, with emails and text messages. One thing I forgot to mention when I was talking about email communications and how to use them tactically, there's an app currently that's a web-based application called Decipher, D-I-C-H-I-P-H-E-R, I think, or D-E-C-I-P-H-E-R, probably the latter. And it gives you a free trial, and I believe it allows you to download text message conversations from your phone. even if they've been deleted, I believe. And it comes with a free trial, which is nice if you only have to go to court this one time to hop on and use this app. I personally have never used it, but I've recommended it a dozen times to people because admitting text messages is complicated. You can't just hand your phone to the judge. I mean, you can in some circumstances, but I don't recommend it, and many judges won't do it anymore. So you want to be able to have these printed out if need be. So turning back, child's development, maintain records of the child's milestones, hobbies, and achievements to showcase an active and engaged parental role. Unfortunately, men these days still have to prove that they're entitled to equal time with their child. New Jersey had recently rejected a statute providing a presumption of equal time, which I personally find repulsive that they would reject that, and replaced it with something along the lines of, generally speaking, as much time as possible. Parents are entitled to as much time as possible. So it still leaves you having to fight for equal time. But that's my soapbox for another day, and the whole reason why my practice is concentrated in men's and fathers' rights. And lastly on this topic, engagement with school. Showing involvement in the child's education, attending school events, and participating in parent-teacher conferences are crucial, not just for your case, but it's good to be involved in your child's learning and development. Play an active role in all of these facets will help you not only with your court cases, but in your overall relationship with your child, as well as nurturing and helping that child grow. Along those lines, many schools now have online calendars. Make sure you have access to that information. You can get the events that are being held in the school. You can often access documents, extracurricular activities. You'll find out who the teachers are and be able to get to know them also. And they will know that you are active and involved, so that if need be for both court or if there's issues with like pick up and drop off, you want the teachers to know exactly who you are. Now let's talk a little more about legal advice. First, initial consultation. 2, evaluating strategies. And 3, getting legal representation. First, initial consultations. Always schedule an initial meeting with a family law attorney to discuss your custody goals and evaluate your legal options. Again, I don't say this because I am one. I say it because it's the best advice. Most of the time, your initial consultations are going to be without charge, so you're at least getting some time and some knowledge. I always recommend that you go to somebody who specializes or concentrates in family law and not somebody who dabbles in criminal and real estate. Not that they're not good attorneys, obviously I can't speak for everybody, but those that concentrate in family law are just better versed in the issues. They will usually be more familiar with the judges. They will have more streamlined processes so that while they may charge more for this expertise, the work is usually done more efficiently and better so that ultimately it is less expensive. I always say cheap is never cheap. 2, evaluating strategies. Review and consider different legal strategies such as mediation, negotiation, or litigation that align with your goals. And this is important. Now, the courts in New Jersey are ultimately all geared towards mediation. Most of the processes is in that direction. There are options for arbitration, but you have to take it outside of the court process with consent of the other party. But when you're speaking to your possible attorney during this advice phase, you want to find out what your options are, both in and out of court, alternate dispute resolution and litigation. You want to get an actual strategy from the attorney that you consult with, and you want to ask for a range of outcomes. And I use these terms specifically because if you ask an attorney what's going to happen, the answer is going to be, I don't know. We can't promise, we can't guarantee, and you really just do never know what's going to happen in court. But we should be able to, or your attorney that you consult with should be able to give you some range of expectation. You're going to pay more than X dollars in child support, but less than Y dollars. You're likely to get this many overnights at a minimal, and our maximum that we'd be seeking is this. And this is how we would do it, and have them map out how they plan to do it. Because if they can't give you that in an initial meeting, then they're not well versed in this area and they're not ready for your case. Lastly, legal representation. Select a lawyer with expertise in custody and family law to effectively represent your case in court if necessary. Meaning you don't have to get a lawyer. You are always entitled to represent yourself. It's never, in my opinion, a good idea unless you just have no choice. But it's good to know that you have that option. And if you do have to do this on your own, we should talk about navigating the court process. 1, court procedures. 2, presenting evidence. And 3, professional support. 1, understand the steps involved in custody hearings and what to expect during the legal process. And I know I sound like a broken record. I do have specific videos on this. Maybe I'll see if I can get some posted in the descriptions below, but that's a little challenging. I'm not as fancy and well-versed as these other YouTubers. I'm just here to help and give some information. But like I said about the court procedure, you want to know the basic phases of the custody process, both the mediation processes and the hearings, the names of what they're going to be called so you understand it, and basically what to expect at each phase. You can get these from my webinars. You can get this online, but you should at least get this from an attorney in a consultation also. 2, presenting evidence. Prepare and presenting compelling evidence to demonstrate a strong case for gaining custody rights. I won't belabor this point. We've talked about a few different areas in this webinar about how to present evidence. I have probably mentioned at every stage there are specific webinars that I have that will assist you. And lastly, professional support. Considering professional guidance and emotional support to navigate the complexity of legal proceedings. This is both professional for you and yourself. Professional support, like I said, lawyers, obviously, counselors and therapists, and possibly expert witnesses to determine custody and what's best for your child. So that could be custody evaluators, that could be friends and family, teachers. All these are going to be professional support for presenting your case, and all these that you should consider when sort of packaging your case to bring it to court if that's the direction that it's going to go into. And also to help you, as I keep urging through all my webinars, that family law is very challenging on the parties, more so than maybe they even realize getting into it, and you just want to be ready to take care of yourself at the same time. So wrapping this up, reflect on progress. It's important to reflect on the progress made in gaining custody rights and celebrate. As I said, it is very challenging, and you need to be cognizant of the ground that you're making, where you came from, because if you're looking at the tip of the mountain, it sometimes looks unreachable. Empowerment, feeling empowered and motivated to maintain a positive and nurturing environment for both you and your child. And lastly, relationship building, continuously working towards building and nurturing a strong, meaningful relationship with your child. This isn't about winning. It's not about getting more and giving more or reducing your support or increasing your parenting time. It's about your child and your future relationship. It's also about your child's future relationship with their children. They're going to learn from you what a relationship and what a parent is, and they're going to mirror that. So be cognizant of what you're teaching them. Anybody wants to contact me or my law firm, here is the website, micklinlawgroup.com. That's MICKLINLAWGROUP.com. My YouTube page, Brad Michael Micklin. I have a Facebook page, Micklin Law Group, and of course we have, all the other LinkedIn's and all that. You can always find us. I would appreciate it if you are watching this on YouTube that you like and share the video. It helps other people get to see this information, which helps other followers. It also makes the videos more circulated so other people will get to see this, and hopefully we can help a greater range of people. Please stay tuned for the legal disclaimer. It says that this is not legal advice. It doesn't create an attorney-client relationship. It's for advertising and everything else that you can see on here. We are required to establish this, and it is important. I don't mean to belittle it. I know you're probably not interested in reading it, but it is important because this is being offered in a vacuum without any facts of the case or the history of your case, and it may not apply, and people can't necessarily rely on this, which is why we repeatedly say get some legal professionals' help. that is the conclusion of this webinar. I hope it helps you now or in your future. Actually, I hope you really don't ever need it. In a perfect world, you wouldn't need this information. It would be established easily. But if it's not, and you have a taxing relationship or a trying relationship, certainly I hope this helps you. I know I say you're probably tired of hearing this before I sign off, but one last time, go to my YouTube page, Brad Michael Micklin, or my website, and just run word searches, custody, arbitration, mediation, and you'll get a plethora of blog posts and webinars that will help you. And if they don't, my website has a link to my virtual calendar. Like I said in the beginning, you can schedule to meet with me. There is no cost, at least currently, for my consultations. I don't have any future plans to change that, but one never knows what happens. But I'm here to help, so I hope I get the opportunity. With that, I wish you good luck, and I'm signing off.